Hello, everyone. We're just going to let everyone get in little by little. We are so happy that you're joining us for this webinar. For everyone, one more minute. All right, I think we can get going. Hi, everyone. My name is Jessica Moradian. I'm the Director of Government Affairs for the Massachusetts Restaurant Association. We are so happy that you're here to join us today. This session is being recorded, just so everyone knows. And I would really like, we are really lucky to have members, staff from the Attorney General's office. We have Justin Polk, who's an Assistant Attorney General here with us. And we have Christina Proietti, who's a senior investigator for the Massachusetts Attorney General's office as well. This will be recorded. You will be able to ask questions in the Q&A box. We're going to save most of those questions for the end because, as they go through their presentation, I'm sure a lot of the questions that you have will be answered. But if there's questions that you have, go ahead and throw them in the question and answer box, and we will get to those at the end. All right. And with that, I will let Justin and Christina take it away.
Thank you, Jessica, and good morning, everyone. Jessica said, my name is Justin Polk. I'm an Assistant Attorney General here in the Fair Labor Division of the Massachusetts Attorney General's office. I've been with the office just under 3 years. I am joined by my colleague, Christina Proietti, I'm sorry, never mispronounced her name before. She's an investigator with the office. She's been an investigator for just under 16 years, I believe, also with the Fair Labor Division and located in the Public Protection and Advocacy Bureau. So Christina and I work together on a variety of wage and hour matters with a focus on child labor. We jumped at the chance to be able to present at the Massachusetts Restaurant Association and kind of give information on kind of the work that we do. So we hope that you find our presentation informative. Just a disclaimer at the outset, our office has statutory authority to render formal legal opinions in just a few limited circumstances. So we cannot provide legal advice specific to kind of individual circumstances. So today's presentation will be informational only, but we're happy to answer any kind of general questions you have about child labor or the wage and hour laws at the end of the presentation. And so with that, unless Christina, you have any remarks, I think we can get started. Great. Let me just see if I can share my screen. Okay, I think we are underway. So the Attorney General's office is an advocate and resource for all of the residents of Massachusetts. So we have a couple of main goals, being protecting consumers, combating fraud and corruption, investigating and prosecuting crime, and protecting the environment, workers, and civil rights. And in fair labor, we focus mostly on that last part, specifically protecting workers and their rights. So how do we do this work? And so you see there's 4 major ways that we go about enforcing the wage and hour and child labor laws. There's basically 2 tracks that we take for investigation. If we find a violation, we move on to enforcement. So you'll see that in step 1. If we do not find a violation, we close the case, or we'll issue a private right of action letter to an affected worker, allowing them to pursue their own civil case against their employer. Our enforcement actions can be civil or criminal, or we can issue an advisory, which is a notice that our office issues, a formal notice that explains the law and provides notice to the employer that going forward, they're on notice of that law. And if there's future violations, we would cite for those violations. We use advisories when there's kind of a minor issue in a case that we're investigating and we're not actually going to cite for that conduct. Prevention. That's what we're doing now. It's education. It's informing employers, informing workers what their respective rights and responsibilities are on the front end before a violation happens. And then policy. We support bills at the State House, and we also issue formal advisory opinions. We have a couple, I think, on our website related to tips, minimum wage, earned sick time, that sort of thing. So you'll see formal advisories as well. So this slide covers kind of the panoply of topics that are within the jurisdiction of the Fair Labor Division. You see a couple of the big hitters: minimum wage, prevailing wage, overtime, child labor, earned sick time, timely payment of wages, labor trafficking. And there's a couple of more nuanced laws: temporary workers' rights to know, small necessities leave act, public construction bid laws. But again, we enforce all of these laws within the ambit of the Fair Labor Division. If they went too far. Here we go. Yes. The Attorney General's role. So we investigate wage and hour complaints. We enforce the law, outreach, and education. That's what we do in FLD. That's kind of our bread and butter. And we have a hotline available for calls, anonymous complaints. If you have a question about, as an employer, about the application of the laws, or if you're an employee, you want to report conduct, our hotline is available from Monday through Friday, 10 a.m. to 4 p.m. And that number is 617-727-3465. Again, 617-727-3465. And if you want to do a walk-in, we accept walk-ins as well. We're located at 100 Cambridge Street, 12th floor in Boston, Massachusetts. So come see us, or you can call in if you have a complaint or a question. So I want to start off with child labor, an overview of the child labor laws. I'm sure most of you are most interested in child labor, since we're starting with the summer work season for a lot of minors, and a lot of these issues might be topical. Just at the outset, we're going to be presenting on Massachusetts law, and we've included some of the federal law requirements as well. We don't enforce the federal standards, but we've included them for informational purposes only. So if you have a question about the federal child labor rules, you would have to reach out to USDOL, but I'll try to point out where there are differences as we go through the slides. But an overview of the child labor laws. So the child labor laws set a minimum age of 14 for employment. They restrict the activities and the work that minors can do for certain types of jobs, and it also restricts their hours. And it contains documentation requirements pertaining to work permits and schedules. And again, remember, both federal and state laws apply. So when you're looking at how to handle your youth workforce, make sure that you're keeping in mind both not only the Massachusetts laws, but the federal laws as well. Hazardous occupations. As you can see, there is a lot that young workers cannot do within the Commonwealth, and it's age specific. So workers under 18, big one, cannot drive a vehicle. They cannot be your delivery driver. They cannot, essentially be your delivery driver or drive an Uber or anything else like that. Operating a vehicle as a part of employment for a minor under the age of 18 is strictly prohibited. Cleaning meat slicers, grinders, choppers. I mean, some of this stuff is obvious. Any kind of dangerous or hazardous work, operating a firearm. Workers under 16 can't be doing any baking, microwave ovens, cooking, power-driven machinery. It's really about protecting workers who don't have a lot of experience on the job, making sure that when they're getting their first employment, they're employed in safe spaces. Allowable and maximum hours. I want to spend some time on this one because this is where Christina and I see a lot of violations with employers. The law set forth when the youth employers are allowed to work. And so you see 16 and 17-year-olds may not work at night from 10 p.m. to 6 a.m. or past 10:15 if the employer stops serving customers at 10 p.m. They may not work more than 9 hours a day. and they may not work more than 48 hours per week or more than 6 days a week. And there's for 14 and 15-year-olds, I'm sorry, there's an exception for non-school nights. So you can work until 11:30 or until midnight if you're working at a restaurant or a racetrack. For 14 and 15-year-olds, you may not work from 7 p.m. to 7 a.m. So hard cutoff, except in the summer. So again, topical. July 1 to Labor Day, 14 to 15-year-olds can work until 9 p.m., but 9 p.m. is the cutoff. During the school year, and this is where we see the federal laws apply. During the school year, they may not work during school hours. They may not work more than 3 hours on any school day, more than 18 hours during a school week, or more than 8 hours on any weekend or holiday. And during that school hour, there's an exception for school-approved job or career building jobs. When school is not in session, 14 and 50-year-olds cannot work more than 40 hours a week, more than 8 hours a day, or more than 6 days in any week. So again, this time period is when we see a lot of the violations where employers are not aware of the hours restrictions, and these can really rack up. These can really, if you are not paying attention, you employ 10 youth workers, and you have everyone working past 9 p.m. in the summer for a couple of days. That can easily be 50 violations right there. So it's really important to pay attention to the hours restrictions and make sure that you are making sure that your youth workers are clocking in and clocking out as appropriate. Work permits, another frequent violation that we see. All workers under 18 must have a completed work permit on application on file when they begin work. You need to obtain the work permit before starting a new job. So, just having the application is not going to suffice here. You need to have the filled out work permit. An employer should maintain that work permit on file. We've seen investigations where we have an allegation that the employer wasn't obtaining work permits prior to allowing youth to start working, and the employer says that, oh, I did have them, but they didn't keep them, or they got lost or something like that. Make sure that you have them on file in case we come knocking, so that when we're looking through your records, you're able to show that you have provided or you have obtained their necessary permitting for youth employees. Permits are granted by the superintendent or their designee in the town where the youth worker is residing or attending school. So you want to make sure that the youth gets that from the superintendent, and again, keep that permit on file. Very important. Scheduling and posting requirements. We don't see many violations around this, but I do think that a lot of employers are not aware of what the requirements are. So, this is, again, citable conduct. An employer must post the number of hours a minor is permitted to work each day, their total hours for the week, their hours when they begin and stop work, and any kind of a time allowed for meals at the beginning and the end of each day. A minor cannot work any time that is not on the posted schedule, and that's very important. And the schedule cannot change after the beginning of the work on the first of the first day of the work week. So once the work week starts and you have the minor schedule set, that is the schedule for the minor for that week. You can't change it. You can't, and the minor can only work those hours that are posted on that schedule. And so again, the rules around scheduling are in addition to the employer's obligation to maintain true and accurate records. So, if we're coming into your business because we received a complaint or we're doing proactive enforcement, we want to make sure that when we're looking at time records, that we're looking at actual punch in, punch out time records. Sometimes employers will try to give us schedules. Schedules are prospective documents. They're basically saying, this is these are the hours that that our workers are expected to work. But as we know, someone can call in sick, someone could have an emergency, that sort of thing. When we come in and do an investigation, we ask for time records. We're asking for the actual punch-ins and the punch-outs, because schedules can be easily manipulated, and that's not what this office looks for. Supervision. probably one of the biggest violations that we have seen since I've started, and I'm sure since Christina started as well. After 8 p.m., all minors must be directly supervised by an adult with supervisory authority located in the workplace who is easily accessible. Each one of those words in that statement is very, very important. So let's kind of break it down piece by piece. So after 8 p.m., all minors have to have direct access to someone who is over the age of 18. That's number one, who is supervisory capacity. So they can't be of the same job classification as the minor. They have to be a supervisor. And that supervisor has to be located on the premises and accessible. So let's say that you have two businesses, restaurant A and restaurant B, that are next door to each other. The manager can't be at restaurant B while the youth worker is at restaurant A. That does not suffice for the statute. Even if you say, well, he could call me if he wanted to, or the minor could reach out to me or just go next door. No, they have to be accessible, not locked in a back room, not next door at another restaurant. They have to be available to the minor at all times. We've seen a lot of instances where you'll see some sort of variation where, I had to step out for a moment, or I ran a quick errand, or I was at my other business, or I was available by phone. No. Or in some instances we've seen where you'll see a convenience store that is located in a gas station, and they leave the minor who runs the convenience store there, and it's like, oh, the gas station attendant who runs a separate business was there. So the minor technically wasn't alone. That person doesn't have supervisory authority over the minor. So you really want to make sure that that you have someone on site for anyone under the age of 18. Again, we see this a lot, and we cite for this a lot. Moving a little bit past child labor to earn sick time. This is a kind of another area where we've seen a lot of violations recently. Earned sick time, the statute was enacted, went into effect in July 1, 2015, so almost 10 years, coming up on 9 years. All employees in Massachusetts should begin to accrue earned sick time that may be used for authorized purposes. And so the law sets minimum requirements for employers, but employers, of course, can have more generous policies than the floor that the earned sick time law sets forth. The law entitles Massachusetts employees to earn and use up to 40 hours of sick time per year. And there's two categories of earned sick time: paid and unpaid. If you're an employer with 11 or more employees, sick time must be paid. If you have 1 to 10 employees, then sick time does not have to be paid. But either way, they still have to be able to accrue up to 40 hours of earned sick time and have to be able to use it for approved purposes. So how do you determine the size of the employer? Average payroll during the preceding benefit year. New employers use a real-time calculation. You also count your temporary workers. You count employees throughout the enterprise, including employees outside of Massachusetts. I think this is one where some employers get tripped up. They think, oh, I have businesses located in several states. I only have one restaurant in Massachusetts that has 10 employees. My earned sick time is unpaid. Actually, it's not. We count all of the employees under that same kind of corporate umbrella or business entity umbrella. And so again, the earned sick time is paid or unpaid depending on the employer size when it was earned. And so I have a quick example here. Again, if you own several restaurants that are organized under a single business entity, and we're going to call that generic Restaurants R Us, Inc., which might run 4 restaurants, we look at the number of employees across all stores run by that entity to determine whether or not the earned sick time has to be paid or unpaid. The purposes of earned sick time, very important. Employees must be able to use earned sick time for the following reasons: to take care of their child, spouse, parent, or parent of a spouse, to take care of themselves, to attend a routine medical appointment or any of the people mentioned above, address the effects of domestic violence, or to travel to or from the location related for the purposes for which that time is taken. So you factor in, when you're using your sick time, the travel time to get to your doctor's appointment or take your spouse to an appointment or something like that. Accruing and using earned sick time. So again, employees earn sick time at the rate of 1 hour per 30 hours work up to 40 hours per year. Again, employers can have a more generous policy that allows you to accrue more than 40 hours. 40 hours is just the bare minimum under the statute. An employee begins to earn sick time on the first day that they actually begin work. So on day one, they should be starting to accrue. All hours work, including hours work outside of Massachusetts, count towards earned sick time. So if you have to travel for out of state for a week or two or a day, the hours that you work while you're out of state still count towards your Massachusetts accrual. And although the employees begin to accrue their earned sick time, an employer can put a grace period that says that you have 90 days, up to 90 days, so you can actually begin using it. So it's not an automatic vesting. There can be, and this is not a requirement of the statute. An employer can say on day one you can start using your earned sick time, but at most an employer can say you have to wait 90 days. And again, employees may only use their earned sick time for authorized purposes up to 40 hours a year. It's not a replacement for vacation time. It is not PTO, paid time off, or anything like that, unless it's being used as earned sick time. Again, it should be for approved purposes. So if you have the Comcast guy coming, you don't want to use your earned sick time for that. You might find that you get in trouble with your employer. And the smallest increment of sick time that may be used is 1 hour. So you're not breaking this down into a half hour, 45 minutes, 15 minutes here and there. It's an hour for each usage. Paying for earned sick time. Generally, employees are paid what they would have been paid if they had worked. So it's basically your whatever your rate of pay is for your job. So if you're making minimum wage, then your earned sick time rate would be the minimum wage. If you're making $50 an hour, your earned sick time rate would be $50 an hour. And employees using sick time, however, do not make overtime or premium pay. So if you worked 40 hours, we're going to work some more, but then had to take some sick time, you don't get overtime pay for the hours that you work that would have been included in the premium pay. That would have been strictly straight rate. And employers must pay earned sick time on the same pay period as regular pay. So if you work on Monday, you're out Tuesday, and you're paid on Friday, then your earned sick time should be paid along with all the other wages earned throughout that week. If you're on a weekly schedule, and then the following week if it's the next schedule, it's a bi-weekly pay period. And then here's just a link to our website on earned sick time. We're not going to go over all of the requirements, but you'll see that there are other requirements related to notice, carryover. The employee must be allowed to carry over at most 40 hours over the benefit year. Breaks in service, we talk about documentation, record keeping, posting, and retaliation as well. All important topics, but we don't have to get into now. Common sick time violations that we have experienced. Number one, and there's a reason why it's number one, straight refusal to allow a day off or to pay for hours. We have seen this where someone is trying to use their sick time and the employer just says, well, I'm not going to pay you for it. That is a violation of the law, and we will cite for that. An employer sometimes will inaccurately claim that they have less than 11 employees so that they don't have to pay for the sick time. When we find out that they actually do. And again, you see the example number 3. An employer owns multiple entities and is not paying for earned sick time at locations with less than 11 employees, even though the overall number across all the entities exceeds 11. Failure to establish and distribute an earned sick time policy, very important. We have seen instances where an employer will say, "Oh, I just give my employees an unlimited time, and they can use whenever they want." That's not a policy. Unlimited time is a subjective is basically at the kind of behest of the employer to grant or deny the use based on the subjective, I don't want to say whim, but if there has to be a written down policy that sets forth the rights and obligations for the use of earned sick time that the employee is aware of and knows that if they use it for improper purposes, there's going to be consequences, and what their rights are if their employer is not allowing them to use their earned sick time for permissible purposes. Unreasonable protocol for reporting a sick day or untimely payment. We've seen that. Inconsistent application, forcing employees to find coverage for their shift if they want to use earned sick time. We don't have to go through all of these. Posting an earned sick time policy in English when the majority of your workforce does not speak English. Those type of things we have seen, again, violations that we have and will cite for. Switching slightly to breaks. All employees must be given at least a 30-minute meal break for each 6 hours, block of 6 hours worked in a calendar day. They must be free to leave the workplace and to kind of conduct their own business while they're on break. So a meal break is not, oh, you go take your lunch in the break room and then report back in 30 minutes. You have to be able to leave the premises. If there's restriction on whether or not you can leave or what you can do on your break, then it's not a break and that time has to be paid. An employee can voluntarily give up their meal break, but they must be paid for the time worked. And again, during a meal break, you have to be free, or any type of break, you must be free from all work-related responsibilities. Meal break waivers should be in writing, and they should spell out that the employee can rescind the waiver at any time. And we pay special attention to this within the child labor context. Minors are often less skilled at advocating for their rights. And so one kind of tip that we give employers is that when you're onboarding a minor, don't slip a meal break waiver in that kind of stack of paperwork you fill out on the first day. We want to see that the minor had a discussion with the employer about what the waiver contained, and they actually know that they're able to rescind that waiver at any time, that they don't have to sign it if they don't want to. We always advise employers steer clear of auto deduction. I rarely see an instance where auto deduction goes well. Auto deduction is basically when your payroll system, be it I don't know what payroll systems are, paychecks or what have you, just automatically deducts that 30 minutes from everyone's pay, expecting that the workers would take that 30 minutes. Again, we get complaints all the time where people are unable to take breaks because it's busy, and they decide they were going to waive, and they still see that auto deduct come out of their paycheck 30 minutes here and there. Again, the employer has the responsibility of keeping true and accurate records. So the onus is on the employer to make sure that when they are deducting 30 minutes for meal breaks, that those meal breaks are actually taken. This is not a responsibility that can be passed off to a third-party payroll processing company or a timekeeping system. The employer has the statutory obligation to ensure that employees are paid properly and that they're keeping accurate records for hours worked. So again, auto deduction, it's not a practice that we recommend, but employers still do it. It's something to keep in mind. Other wage and hour laws that we have seen come up: tip pooling. If you're going to run a tip pool, which is when all the service staff kind of combine their tips together and get tipped out, funds must be distributed only to service wait staff employees. So employees with managerial responsibility and owners can never, and I repeat, can never participate in the tip pool. If you're a general manager, you, by definition, you have management responsibility of the business, and therefore, even on days when you might be waiting tables, you are still the general manager, and you cannot participate in a tip pool. Tips that are given directly to a manager, I think, when let's say, for example, if the manager is the only one who's in the shop and they're waiting tables and someone gives them a tip, there can be no confusion that tip was intended for the person who served them. And in that sense, there is no tip pool because it's just the manager on site. That manager would be allowed to take the tip. But if you're sharing, if there's actual tip pool going on, a manager cannot participate, an owner cannot participate in the tip pool. Uniform deductions. It's unlawful to deduct from an employee's paycheck for uniforms or for uniform cleaning. And so if you require your employees to either rent or purchase a uniform, they have to be reimbursed for that. And then there's a uniform deposit waiver from the Department of Labor standards, but we don't see too much of that. Enforcement. As I said before, we have two types of enforcement: civil and criminal. Our authority actually started off as exclusively criminal, and then I think there was an amendment around, was it 2000, Christina, maybe somewhere around there, where we actually were given civil citation authority. Civil citations, usually when we conclude an investigation, there's usually a citation that or more that comes with it. It will order restitution if applicable. There will be a penalty. It includes a right to appeal to the Division of Administrative Law Appeals, and then failure to pay or appeal, failure to do either will result in a tax lien. So just a little bit of background on this. Criminal enforcement, it involves going to a grand jury, securing an indictment, arrest, and criminal trial. You might have seen that recently with some of our labor trafficking cases. Civil is usually just the civil citation and the penalty. The primary aim of all of our enforcement is to, get restitution that is owed to workers. So if we can do that through civil enforcement, fine. If the employer is not cooperative and is, throwing up obstacles and every step of the investigation, we might have to look to criminal to make sure that we are actually, enforcing the rights of the workers. As I said before, regardless of the investigation, we usually attach penalties. Child labor violations are penalized at a max of $250 for a first offense, $500 for a second offense, and $2,500 for a third offense. So going back to my original, I think, example of the hours violation for some minors. If the minor is supposed to stop working at 9, you've got 10 minors and they all work after 9 p.m. Each one of those is a violation. And so when you look at the statute, you see that we can cite for each violation up to $250 for a first offense for child labor. These numbers really do rack up. And so it's in your best interest to kind of strictly adhere to the child labor laws and make sure that you're running your business in accordance with them. Regular wage and hour violations, so things that are not specific to child labor, can be cited up to $7,500 for a first unintentional offense, $15,000 for an intentional offense, and $25,000 for a subsequent intentional offense. So let's say that we have reached out to your business and said, hey, we received a complaint. We want to see payroll records from May to June. And you respond via email saying, no. It sometimes happens. That would be an intentional failure to furnish, for which we could cite up to $7,500 for a first offense. I'm sorry, up to $15,000, because the intent is, I'm not going to give you the records. I know I'm supposed to. I'm not going to do it. We don't cite to the statutory max often. It really does depend on the specific facts of the case, and I think we might later go into what the statutory factors are. There's a lot of discretion in there. Again, these citations may be applied per victim per pay period. So again, let's say that you have a minor that doesn't have, and this we don't apply the work permit statute this way, but let's say that there's a minor that doesn't have a work permit for 6 months while they're working. We could cite for every pay period that minor worked without a work permit, because it's a continuing violation. Again, we don't apply at least a work permit statute that way, but it's something to keep in mind when you're looking at, what your liability and what your exposure is to some of these citations. Employers, of course, have a right to appeal The right to appeal is 15 days within the receipt of the citation. And again, the written notice must go to DALA and to the AGO. And so it's a 200. I think DALA has a $200 per citation appeal fee. But again, the appeal has to go to DALA and to the AGO. If you only send your notice of appeal to DALA, and DALA will throw your appeal out, and then you're looking at the tax lien if you haven't paid anything towards your citation. In lieu of appeal, you can make payment within 21 days of the receipt of the citation. We often, based on whether if a employer during the course of the investigation has gotten into compliance and has been cooperative throughout, then we can offer a settlement agreement, payment plan, those sort of things to help stretch beyond the 21 days, especially if the citation numbers get up there. Failure to pay, though, does result in a tax lien issued by the Department of Revenue that accrues 18% interest against all persons, and we usually list natural persons on the citation. So if you're the president of the corporation, or the president of the restaurant, or what have you, then your name would be listed on the citation, and that would appear as a tax lien against you as well. I think we're reaching the end here. If contacted by the AGO, in sum, the duty to furnish records is established by General Laws, Chapter 151, Section 15. Employers have the duty to furnish to the AGO any requested payroll or personnel records on demand. On demand is what the statute means, and is what DALA in its appeal decisions has interpreted to mean. Is when we come asking for documents, they should be ready to go. We usually give a grace period, so we'll say we've received a complaint, we're asking for these records, please furnish them in 2 weeks. Or if the employer is like, I'm going on vacation tomorrow, we can work with you on the date that they're submitted. But again, the records should be ready to go. The DALA has said the AGO should not have to ask twice for documents. So ignoring is not in the best interest of anybody to ignore the request. Working with the AGO, communication is important. If you run into an issue when we're investigating, reach out to either the investigator or the AAG involved, or if you have legal counsel, have them do it. Silence is not your friend when you're dealing with one of our investigations. If we don't know what issues you're experiencing in producing documents or getting the information that we need, then we can't work with you. And that's what we try to do with these investigations. We're not out to get anybody. We're not out to just jack up the citation numbers or the penalty amounts. We're really trying to, as I said before, ensure that all workers get what they are owed under the law, and to make sure that these kind of violations that we uncover don't happen again. So to inform the employer what happened, what went wrong, and how going forward this doesn't happen again. Again, the mission of the Fair Labor Division is to educate as well as enforce. And I think I've already said, don't ignore inquiry from our office. Don't actively thwart us in our investigation. Hindrance is a separate offense, different from failure to furnish. So, if you're telling your workers, don't talk to the AGO, don't tell them this, don't tell them that, that could be a hindrance citation that is subject to the same penalties as I've mentioned previously. Retaliation, last but important. An employer may not take any adverse action against an employee for complaining about wage and hour violations and for helping with an investigation. Employees are protected by statute for asserting their rights. So, if you find out that one of your employees made a complaint with our office, okay, don't do anything. It's not in your interest to take any kind of action against that employee, because if we can substantiate a retaliation claim, we will. We are very protective of workers' rights and of the right of workers to come to us and bring to our attention issues that they're experiencing. So, if there is a retaliation citation out there for conduct by an employer, we will pursue that. And that's especially the case with, again, and I shouldn't have to say this, with with youth workers. A lot of the youth workers, they are on their first jobs, they're experiencing the workplace for the first time. No one wants to be the person that ruins it for them by retaliating against kids. That's just never a good look for a business. But with that said, I think we have reached the end. Am I ready for questions?
Great. Thank you so much, Justin. We have a few questions that have been sent here, and I've gotten a few questions privately as well. I think that I would love to start with the first question that I got that says, what if a minor wants to change their schedule after it was posted for the week? What if the minor is sick? Is it on them? What happens with that?
So are you saying what if the minor is like sick?
Let's talk about the minor being sick, or what if the minor has a activity that they want to do that comes up and their schedule is going to change?
So if the minor is sick, they would have available to them the earned sick time. So there wouldn't necessarily need to be a change of schedule. Christina, do you have thoughts on if the minor wants to change their schedule? I'm asking her because she's also a parent, so it's fresh in her mind.
Good.
No, I think the main thing that we would look for in investigations is that things are agreed upon. So if you have a posted schedule and I guess ultimately documentation is key. If you have the minor maybe put in a request that they want this time off and everybody signs off on it, and then there's a change to the schedule. What we're looking for in the investigations is when schedules are changed without notification. And again, when they fall into exceeding the latest permissible hours and things of that nature. So if there's an agreed upon change of schedule, even if that allegation came to us, most likely that would be a conversation we could have. And if the employer has documents to support it, it's not going to be an issue to us. It would be a conversation and then, move on from there.
Great. And then on the topic of minors, are minors allowed to purchase their own uniforms?
So they can. Is the question about like a required uniform?
Yes.
So I believe they would have to still be. They can purchase them, but I believe they would still have to be reimbursed for that.
Perfect. Youth workers working after 8 o'clock in a shopping mall with 24-hour security staff. Is that okay without a manager there?
No, there has to be someone from the actual business who is on site and available. That example is kind of like the one I gave with the youth worker working in a gas station that might have like a convenience store. And after in the convenience store, the employer is like, well, the guy who runs the gas station is still there. So if anything happens, he's around. Like that's not. There has to be someone with supervisory authority within the corporation that is on site and available to the minor.
Right. Perfect.
Could I go back and expand upon the uniform question?
Absolutely. Please, Christina.
So basically the bottom line is a uniform deduction cannot be made to payroll. But if an employee is provided a uniform and then wants extra uniforms, in those cases, an employee can choose to, let's say there's logo gear and the employer furnishes, a t-shirt and everybody wants to get hoodies that are logo. People can purchase additional uniforms, or they don't want to do their laundry, every other day coming in. They can request to purchase additional on their own, but it cannot be deducted from payroll. And if the uniform is such that it's not logo, if it's what's considered streetwear, there are regulations in the Department of Labor Standards has a topical index which outlines some of these regulations. And it says if the uniform is streetwear, then people can purchase that on their own. Maybe, for example, banquet staff have to wear black pants and a white shirt, and they can go anywhere within parameters and buy that. And then that's something they can wear elsewhere. But if it's so specific that it's job related or again has logo, that must be provided by the employer.
Great. We are getting a lot of questions too about earned sick time, let's go over to some of those. If we have a lot of employees that obviously in the restaurant industry that are tipped employees making service staff wages. Can you discuss a little bit about how folks have to pay out those wages when it is earned sick time?
Yeah, so I'm just making sure I wasn't on mute. Yeah, so the rule is that they have to make at least the minimum wage. So if you're paying out earned sick time, it has to be at the minimum wage rate for tipped service workers. So that would be the $15 an hour now.
And if someone requests sick time too late after the pay period has been finalized, can an employer pay their sick time the following pay period?
I will let Christina handle that one.
So with this situation, is this meaning, let me think about this, because I would assume the time would have been requested off during the week.
I don't think it's not time off though. What if it's earned sick time, right? So it's that day and the employer would be paying, a tipped wage normally. And in this case, if they didn't show up, they called the day of, it would end up being a minimum wage situation, a $15 an hour wage. So could that be made up?
In those situations, I mean, we would always tell an employer to, never withhold payment, always make payment, and then the matter can be remedied after. I mean, that's a very case specific question. So again, if it came to our office as a complaint, it would be a conversation with the company. We never jump to the point of just an aha moment where someone complains and we just issue out a citation. There's 99.9% of the time, there's going to be a conversation. There's going to be an email or a letter sent to the company where they can provide those kind of details and more specifics. There's not just going to be an automatic citation in the mail for them if an employee says, they didn't pay my sick time on time, that kind of thing. So I think that would be very case specific. But as a person processing payroll, do your best to get that person paid in whatever manner they can be at that time, and then remedy the situation as soon as possible.
And on the same topic a little bit, when someone works multiple positions and one of those is paid higher, the non-tipped wage, I think we've established a little bit because I've gotten this question a little bit more. Do they pay the higher rate? Yes, you have to be paying folks minimum wage at the regular minimum wage level, not the tip wage level.
Right.
We've gotten a few of those. I've also gotten a few folks asking me, and I get this question a lot, Justin and Christina, just on a regular basis about accruing earned sick time. If an employee accrued 40 hours and uses some of that sick time, say 20 hours, does the employee continue to accrue up to 40 hours again, knowing that they can only use 40 hours? If you can talk about accrual a little bit, that would be great.
So it's the accrual is a max of 40 hours per the statute, but the employer's policy can be more generous. So let's say that if you're going strictly by the statute, and so that you're accruing 1 hour for every 30 up to 40 a year. Once you've accrued up to 40, kind of that's it. So as you're using the time, if you've used 20 hours that you've accrued during the year, you can only accrue the extra 20 per the statute. If the policy your employer's policy allows you to do more, then of course you can do more. But if you're just kind of using the basic standard state EST policy, it's up to 40 hours a year. And so as you're using that, you're deducting from what you're going to be accruing. It's not a rolling metric that we use.
Another question I'm getting a lot, Justin and Christina, is about minors again. Few folks are asking if an employee is trying to get their shift cover and they offer it to a minor without letting anyone else know, or if the minor gets their own shift covered by another minor, can the minor cover the other employees? without what should happen there?
So I mean that's kind of where you're gonna run into trouble with the scheduling.
Yeah.
And I think that's kind of the reason why. And again, these are instances where we would have to have a conversation with the employer to find out exactly what happened and who was asking who to do what. Under no circumstances should the employer be going to the minor and saying, "I need you to work these hours that are not on the schedule because so and so had to call out or what have you." That's kind of your classic case of a violation. But things where like a minor's asking another minor and they agree and that sort of thing, we'd have to talk to the employer, talk to the employees to see exactly what happened and see if there actually was a violation there.
Great.
I will note also, and this is not advice, but just saying we've heard from many other companies, both in the restaurant industry and others that hire minors, that many companies are moving with all the choices for different online timekeeping and POS systems. More and more of those these days are offering parameters that can be set to alert management or ownership of the hours limitation. So that information can be entered into and alert people so that on a daily basis, the manager, on top of trying to run a business and a busy restaurant and all those things, doesn't have to be thinking, how old is that person over there and how many hours did they work this week? They have it in their system to give them those notifications. And there are even companies not publishing this information to the general public to not put children in any kind of danger, but doing internal color codings, whether it's the color of their name tag or maybe a slightly different color jersey or hat or whatever they wear, so that management knows how old each of their employees are. With just a quick glance to say, no, you can't stay late, you can't work a double shift because, I see that you're, because it's hard to remember all your staff, we understand that, but there's little tricks that companies are putting in place to kind of help them stay in compliance as much as possible.
And Christina, just because you brought up uniforms, I have a question about uniforms. If an employee, they don't turn in their uniform, is it okay to deduct those costs from a last paycheck?
No. No,
That
they cannot
will,
withhold. They cannot withhold a paycheck or deduct that fee from the wages.
yeah, that will earn you a non-payment of wages citation. Generally, what we tell employers, because we see this not just with minors, but also with adults. Someone walked off the job and they took the tools with them or something like that, and we tell the employer like, sorry, the statute says that you cannot make this deduction. You have to pursue a civil action against them or something else to recoup your costs, but you can't deduct that from wages. Those were wages earned, and they have to be paid to the employee.
I have a few questions about digital schedules. If we can talk about that a little bit, are digitally posted schedules acceptable by your office, or do they have to be physically posted in the workplace?
I'm not sure if we've run into an issue with digital schedules, have we, Christina?
I mean, our regulations are so old, they don't encompass those types of answers, but the bottom line is that if they're posted, they're posted. So if there is a mechanism that all employees have access to that information and it's easily shareable, then that would satisfy. Much like, when companies switched over to the majority are now direct deposit, and we ran into issues where people weren't getting pay stubs. As long as that information is accessible to employees, and if everybody does not have online access, if the employer makes it accessible, has a manner on the job site where people can access this information, if they don't have their own, personal access, then in most circumstances that satisfies us.
And Christina, would that go for meal breaks as well? If they have a form that they want to fill out, if they have that in writing digitally, you guys would be happy.
We are seeing more people doing that. I think, I don't know if it's Toast or one of those programs where they are at clock in time, allowing the information is an employee gets prompted to answer the question if they choose to waive their meal break on a daily basis. So we have seen, and some of those records are difficult to print for our office when we ask or we receive a letter saying to provide us. So, as long as, going back to what Justin said at the end of his presentation, as long as you communicate with us and tell us you need time to produce these records or find a manner to produce evidence to us, we're willing to work with you. And again, as long as you communicate with us.
Yep. I have a few more minor questions. If someone has multiple locations, is it necessary for a work permit to be obtained for each one of those locations if the minor is going to work at more than one of those locations and those locations are in different cities?
Well, that was a complicated question. So the minor is going to be moving from one city to another to perform. I just don't know what type of business this would be, where that would happen.
If a restaurant has multiple locations,
Yes.
let's say they want to work, we have a minor that wants to work in 2 of those locations, and those locations are in different cities. So one day they're working in Westboro, where I am, and the next day they're working in Springfield, where Christina is, right? Do they have
If the corporation is one corporation, then one work permit covers that. If they have multiple locations, I was actually going to speak more to the work permit, and that was one of the things that I was going to mention, is that work permit is job specific, but by that we mean employer specific, because many times we'll ask a company to produce the work permits, and let's say, a restaurant will produce us a work permit the minor had from a retail store they worked at previously, because that minor brought them that work permit and maybe nobody looked it over to see it wasn't applicable to the restaurant. That doesn't count as a work permit. The work permit is for the employer. So in your example, if this company is, Restaurant Incorporated, and they have 5 locations that are travelable by that minor, or, then that's one employer. If they have numerous corporations, it would probably be expected to have them for the different, because they're considered different employing entities, if there's different payroll, things of that nature. And I did just want to also reiterate, Justin mentioned it in his talk, that when we ask for the work permit, we do need the issued work permit. We do get a lot of work permit applications produced to us, which is step 1 of the process, where a minor gets the permit application, brings it to the employer, where the employer is supposed to sign it, and they keep that. And that's not actually technically, the permit is supposed to go back to the school system and have it reviewed by the superintendent or guidance office or wherever it is, and they issue the permit that's then brought back to the employer to keep on file. And then just one more note, and this is more the responsibility of the minor, but as the employer, you're telling them you require this. Most school systems have now put their work permit process online. So this is ever since the pandemic, most of that moved online. So it does kind of make it a little easier, more accessible, to require that minor to go get that before you allow them to start working for you.
And one final note on that example with the multiple restaurants, and the minor wants to work at at all of them, or some of them, more than one. As an employer, just keep in mind that you would not assign any job duties to that minor that might involve them traveling between the 2 restaurants. That would be a hazardous work again, and open you up to a citation. The minor cannot have any responsibilities that require them to operate a motor vehicle as part of their job.
And just because we were talking a little bit about, corporations in general before, does earn include common ownership, or does it go by tax ID? How do you guys determine where you're accruing?
So I think every employer is responsible for the earned sick time. So if you are an employer, you would be responsible for. So let's say that you work. Let's say that you work 10 hours at one job and 30 hours at the next job, you would be accruing based on the number of hours that you work, that 1 hour for every 30 at both locations.
So I think the question though is it separate at those different locations, or is it when in your example, Justin, there was 30 and 10. Is that 40 hours or is that 30 and 10?
I think that's 30 and 10. I think that you're accruing under this employer here and you're accruing under this employee here. And so like you might have 15 hours there and 2 hours here because you're working part-time. Does that sound right to you, Christina?
How do we determine if they're two separate employers? Is it by tax ID? How do you guys determine that?
That's a joint employer analysis that's might be outside the scope of this talk. At least there's several court cases and a lot of factors that you look at when you're determining, is this just one employer or are these both employers jointly liable for an employee's work? So that's a kind of broader topic for another day, perhaps.
Okay. But just because we are talking about earned sick time, what can an employer do if they want proof that an employee is using earned sick time? Can they require a doctor's notice to prove illness? I get that question a lot, but I'll let you answer.
So the statute provides, I think it's either 3 consecutive shifts or 24 hours of work that the employee has missed. That is when the employer can request a doctor's note. So if you missed 1 8-hour shift and you want to come back to work the next day, the employer cannot say you need to have a doctor's note to prove that you were using it for an improved purpose. It has to be that 24-hour consecutive work hours or 3 days out.
Thank you. And I want to be very respectful of Justin and Christina's time. So I think we'll end, if that's okay, of talking a little bit about tip pooling. A few questions I get around tip pooling. What if, there is a manager on site, an assistant manager, and someone calls out that they're a tipped employee, the assistant manager jumps on the floor and starts working as a server. Can they collect their tips and be participants of the tip pool or not?
It depends on if there's any other wait staff working that day. If there's any other wait staff working that day, the assistant manager cannot participate in the tip pool. But if they only had one wait staff assigned and that person called out so that the assistant manager had to jump in and they're the only person serving as wait staff for that day, then they can participate in it. And it's really not a tip pool, then it's more all the tips are going to one person.
And then I'm going to end just with a few questions about the current ballot question. I know that's coming up. Have you guys thought at all about what happens if there are 2 laws in place regarding the tip pooling contradiction? Right now the ballot question that is before us is not specific to managers and assistant managers. It doesn't say that they can't participate in a tip pool. Has your office thought about that at all?
I haven't been involved in those discussions. I don't know if we've taken an official position. So I couldn't comment on that. I don't know that we've taken a position on either of those ballot questions.
Perfect. I understand that. Just something then for you guys to take, because it is a question that we get a lot and folks are thinking about. So with that, I would really, really like to thank Justin and Christina for their time. If there's more questions, you can direct them to me, and I am very happy to answer them. If I can't answer them for you, if it's okay, Justin and Christina, can I shoot you over those few last questions?
Great, yeah.
That'd be wonderful. Thank you again so much. We really appreciate your time and your partnership. You guys have been wonderful. And if there's anything in the future, we're always here for you guys as well. And we thank you.
Thank you.
Thank you very much. Bye.
Bye.